SJC-13355, Commonwealth v. Melissa Pfeiffer.
Okay, Attorney McLean, whenever you're ready.
Thank you. Good morning. May it please the court, Ian McLean on behalf of the Commonwealth. The question here is simply whether Judge Sanders abused her discretion or committed other error of law by allowing a Rule 25b2 motion after this court had already conducted direct appellate review and affirmed the convictions below. The answer to that is yes, for three reasons to simplify the argument. The first is that she ignored principles of direct estoppel on multiple occasions and chose to rely in part on things that this court had already concluded she could not rely upon. The second was her decision to apply this court's holding in Brown eliminating felony murder. She chose to apply that retroactively when this court had expressly stated that that holding was to be prospective only.
May I ask you a question? My memory is that Rule 25 is said to be parallel in some regards to Rule 33E, and in that the power is similar and the considerations are similar. The SJC, we didn't have 33E review in this case because it was a second-degree murder, correct?
That's correct, Your Honor.
So if the judge is looking at this through Rule 25, her powers at that point would include what we would have normally considered the Rule 33E powers. It wouldn't have been limited to first-degree murder, would it?
Well, that's correct, Your Honor, but this court has never said, this court has analogized 25b2 to 33E, never said it's expressly the same. So it is sort of, Rule 25b2 is sort of a grant of almost like an equitable kind of power. And the Commonwealth would put forward that while this court has never actually expressly limited that power to pre-direct appeal, that's really where that power makes sense. The trial judge just saw the evidence presented. 25b2 is frequent.
There's no time limit in Rule 25, right?
Correct, Your Honor. The wording of the ruling itself does not have a time limit, and this court has never limited it to pre-direct appeal. But if you look at where the rule is placed in the rules of procedure, it comes before the rule applying to verdict. It comes well before post-conviction relief in Rule 30. And the Commonwealth would say that really that rule is appropriately placed in that window of time after the jury has returned a verdict and until the case enters direct appellate review. However, that would be a change in the law. The court has never held that. So we're not saying Judge Sanders abused her discretion.
Yeah, nothing precludes a judge from saying, I got it wrong, I'm going to have a lesser included.
Correct, Your Honor. Correct, Your Honor. And the Commonwealth would say that the judges are empowered. The trial judges.
It keeps company with Rule 30, basically.
This court has said that, Your Honor, but I'd note that there are several differences there. Rule 30 expressly contemplates adding additional evidence to the record. Look at Rule 25. There are no references to adding additional evidence to the record.
But there is in 33E, right? These are the analogies. We did it in Dowds. We did it in Kolanovic. We've looked at additional evidence in those cases. Well, under 33E.
Yes, Your Honor. Under 33E, you're going to review the entire record. And there, in theory, the case would have gone through not only the trial, but arguably a post-verdict 25b2 and a Rule 30, where the trial record would have been supplemented with some evidence that would then be part of the package that made its way to the court for 33E review. Here, what we have is a situation where closer to the Arias case that this court released in 2021, where we have a post-verdict 25b2. There it was 9 years afterwards, not nearly as long here, but still here we have a post-verdict 25b2. To get around what would normally be no additional evidence in a 25b2 motion, what they do is file a Rule 30 motion in conjunction with it, where the rule expressly contemplates the addition of additional evidence to the record. Now they're backdooring additional evidence into a 25b2 claim. We see this a lot, and sort of the bleed between the two is part of the result. This is part of the result of the bleed over between the two.
But both go to the interest of justice, correct?
Yes, Your Honor, both do go to the interests of justice. But I would point you to the specific material that was included here that was beyond the trial record was the supporting reports from the defense's expert and from another forensic psychologist that didn't even testify at trial. So even if this court were to stick with Pagan and allow someone to supplement the record in a 25b2 motion with stuff that wasn't presented at trial, this is beyond what the court has permitted in the past. Pagan, it was limited to the expert report of the expert that testified at trial. So the same theory that was presented at trial, just additional information from that same expert, that at least that expert was subjected to the crucible of cross-examination.
We've never held the B2 allows for evidence that's not outside the trial record.
Correct,
right?
Your Honor.
We just said it in the context of 33E, and that's the analogy, basically.
Correct, Your Honor. Correct, Your
So
Honor.
there's no rule one way or the other on that issue.
No, there is no rule one way or the other. Pagan is the closest case to it where the expert report was considered. But again, Pagan was a 33E, not a 25B2.
But counsel, if I could go backwards for a little bit, I hear what you're saying about how this might be a little bit further afield from Pagan, but the intent issue was challenged all through the underlying trial, and that she didn't fully understand the consequences of what she was doing. So wouldn't all of those personal characteristics that came out after the fact be consistent with that?
Well, Your Honor, I would say that the expert reports go beyond what exactly came out in trial. And I would point again to Dr. Pfeiffer's expert report, who didn't even testify at trial.
Who was Dr. Pfeiffer's, which side was she on?
The Commonwealth retained Dr. Pfeiffer to do an evaluation. The Commonwealth elected not to present that witness at trial. But so here now we have the trial judges considering not just the trial record, which the Commonwealth would say that's what Rule 25B2 is designed to allow them to do, as you note even from the standard of review where it says extra deference to the trial judge because they observed the witnesses. Here we're now supplementing that trial record with additional information that then bolsters what happened at trial without the Commonwealth's ability to cross-examine any of it. So here, yes, intent was an issue in the case, but had the Commonwealth known that either felony murder was going to be eliminated in the future and that would present a problem for us in this case, or had the Commonwealth known those things, they might have presented a different case. We might have retained a different expert if the Commonwealth didn't care for what Dr. Pfeiffer had ultimately concluded or opined. We might have sought additional information. We might have presented additional witnesses. So the case could have been entirely different.
But the case, remind me if my memory is wrong, the case went to the jury on second degree on the 3 intents, and the jury didn't find second degree in that regard.
That's correct, Your Honor.
Okay, so now, and also I hear your point loud and clear about this is beyond the record at trial. Nonetheless, under 25B2, if the instruction to the judge is this verdict consonant with justice, and if she heard the case, isn't she able to apply that standard regardless of what a ruling might have been on prejudice or substantial risk on a jury instruction?
Well, Your Honor, if I understand your question correctly, we're sort of addressing 2 of the 4 bases that she relied on. The first is the defendant's characteristics or personal traits, and this court has always held that alone can never be a sufficient basis to reduce a verdict under 25B2.
I thought first was the intent.
Excuse me, Your Honor?
I thought first was the intent, that the evidence of intent was really slim, and if you combine that with the second, the personal characteristics.
Well, yes, Your Honor. However, I would say that Judge Sanders was stopped from concluding that the evidence of intent was weak, as this court concluded in direct appellate review, the evidence of the defendant's
That was
intent.
again, I'm testing my memory.
Yes, Your Honor.
I think that was on the sufficiency issue.
Yes, Your Honor. So the court noted that after it had concluded that the correct mens rea for arson it's a general intent crime with malice, not specific intent. The court then noted in an entire paragraph the evidence of the defendant's general intent with malice was overwhelming. That was this court's word on direct
That was on the
appellate review.
harmless error issue, right?
Excuse me, Your
That
Honor?
was on harmless error.
Well, yes, Your Honor, but the majority of the court did note that even if we were to consider the error issue preserved, it was harmless. So
Right,
it was,
right. We did right. It was overwhelming. Evidence of intent was overwhelming.
Yes, Your Honor. So I would respectfully say that
Viewed
that...
in the light most favorable to the Commonwealth, right?
Well, Your Honor, the court then goes on from that paragraph where they describe the general intent as being overwhelming to analyze the sufficiency under the specific intent instruction that was given. And that's where the court really evaluated the evidence in the light most favorable to the Commonwealth.
But wouldn't that have been in the light most favorable to the defendant if we're looking for an error?
Yes,
No.
yes.
Yeah.
Yes, thank you, Your Honor. Thank you, Your Honor. So I would say that the issue of the strength of the evidence on intent was raised, litigated, addressed, essential to the conviction, and the defendant had appellate review, as we're talking about what happened during appellate review. So
But
I would say Judge Sanders was stopped from...
I guess this is the part that becomes the rub, because if we're doing that on the direct appellate review, is the judge limited to looking at it in the light most favorable to the Commonwealth under Rule 25? Because if she's not, why can't she go back and say, this isn't overwhelming, and this is a really close case, and then go on to do the analysis about whether or not this would be consonant with justice?
Well, Your Honor, I'd respectfully say you're inviting trial judges to then second-guess this court in every case. And now the finality of direct appellate review becomes almost meaningless, because every defendant...
You could say that, but I know we've had cases before where I believe it was the Woodward case where, I know that was some time ago, but Chief Justice Marshall said, we've gone back to look at how many times we've gone through this, and it wasn't an overwhelming number of times that trial judges have gone back and revisited the underlying jury verdict. So it's not like we're opening floodgates here.
I hear what you're saying, Your Honor, and when the court looked at that point in time that the Woodward opinion was, which I think was 99, if my memory is correct, I'd say it's a different world now. And if you openly acknowledge and embrace the trial judiciary's ability to second-guess this court whenever they want, you're undermining this court itself, and you're undermining the finality of direct appellate review.
We try and take away from our caution that this is supposed to be done sparingly.
Correct, Your Honor. Correct, Your Honor. So, I mean, here, Judge Sanders, from the Commonwealth's perspective, ignored direct estoppel at least twice, and then decided Brown could be applied retroactively as well. So, sending the message to the trial judiciary that that's not an abuse of discretion tells them that they can second-guess this court whenever they want.
Well, here's my concern and my confusion, or I should say my concern. Judge Sanders gives us 4 reasons for doing what she did. And let's just say I agree with you on the Brown issue and on the jury instruction issue, that's out. We've decided that she's a stop. But looking at the first 2, right, and saying the evidence of intent and then the personal characteristics. If we were to say that there is nothing in Pagan that says it has to be limited to what the expert testified to at trial, that this wasn't an abuse of discretion to listen to or take in this evidence. On the first 2 issues, the intent issue and the personal characteristics, wouldn't that be enough to support her decision under Rule 25?
Hypothetically, yes, it would be, Your Honor. However, I'm going to push back on the defendant's personal characteristics to start, and just remind the court that Pagan was limited to one expert that testified at trial and that expert's report, which elaborated on their testimony. So at least that expert was subjected to the crucible of cross-examination. Here, we have not just the one expert that testified at trial, but we have an entirely different expert that didn't testify. Now, she wouldn't be allowed, no trial judge would be allowed to allow a motion for a new trial under Rule 30 on those materials alone without at least an evidentiary hearing. I mean, here we didn't even have an opportunity to challenge those opinions that were put forward in those expert reports. So this case is categorically different than Pagan, although the Commonwealth maintains that even Pagan was wrongly decided, and the judge shouldn't have been allowed to look at outside material from the trial record at all. But if the court's not willing to revisit Pagan, then here, this case is another step past Pagan that the court really should not permit. As to the intent argument and her evaluation of the evidence on intent, I put forward, Your Honor, that she's again evaluating the intent as specific intent, and it's basically the same error that she made during the original trial. This court let us all know arson, because it was a common law crime, when it was codified, they were incorporating the common law provisions of arson, and it's a general intent crime. So all of her analysis looking at whether the defendant intended the consequences, that's specific intent analysis, and that's not the correct analysis for arson in the Commonwealth. Here in the Commonwealth, it's general intent. We don't concern ourselves with whether she intended the downstream consequences. And that's the analysis that Judge Sanders did here. And I'd
But
say,
what about this analysis? So again, the overwhelming, you'll remind me if I'm wrong, was on general intent as it relates to sufficiency. The majority found that it wasn't preserved, and even if it were, but it's not preserved, that the case was not about an accident, and that the Commonwealth's whole theory of the case was an intent to light the fire, and the Commonwealth's evidence of what happened afterwards was probative of that intent, including the disagreement on the facts as it relates to the locked door. All well and good, but why under 25B2 can't she look at consonant with justice and the intent more broadly? It's not an answer, it's a question.
Yes, Your Honor. I'd say for two reasons. First of all, the Commonwealth's position, then it would take this court reversing some of its prior cases, is that 25B2 in the scheme is really only appropriate between the time of the verdict and when the case enters direct appellate review. That's where 25B2 should be. That's where it should happen. The court has sort of muddled and allowed Rule 25B2 and to slide in with Rule 30's post-direct appeal. And I point you to, Your Honor, I see I've expired my time. Can I complete the answer?
Of course.
Thank you. I'd say if you take a look back at Gilbert from years ago when former Chief Justice Gantz was on the trial bench, and he did a similar sort of thing, allowing a 25B2 after direct appeal. But what he did there was say, okay, this is a Rule 30 issue. There was a problem in the murder one instruction here. That problem doesn't infect the rest of the case, only the aggravator to murder one. This case is really old, so Commonwealth, what I'm going to do is tell you, I'm going to allow this motion for new trial, or you can accept a reduced verdict to murder two, right? And that case, that Gilbert case, has sort of led, I think, to some muddled thinking about 25B2 applying after post-direct appeal. When really what then trial court Judge Gantz did was really something that's inherent in the Rule 30, was instead of allowing a full motion for new trial, I'm going to reduce it to an area where this error of law didn't infect the case. So that would be a situation where you would see a 25B2 type reduction in verdict post-direct appeal. But here, we're not saying that there was, or Judge Sanders didn't say there was any sort of error at all that infected the case. She's just decided not consonant with justice. And the Commonwealth would say that power is properly limited to the trial judge from the moment that the trial concludes until the case enters direct appellate review. And it's appropriate for them to have it there because they sought and presided over the evidence itself, and there may be a situation where they need to reduce the verdict as a result. But here, the case entered direct appellate review, went through direct appellate review, was affirmed, the victim's family was put through all of that. This court has repeatedly said that direct appellate review means something, the finality of convictions means something, not just to the victims and the families of the victims, to the Commonwealth itself, and to deterrence. Direct appellate review has to mean something. We can't allow trial judges to then, 2 years later, 10 years later, 20 years later, rip open the wound and decide, well, I feel terrible for this victim and her hard luck upbringing. And as a result, I'm now going to reduce the conviction. That can't be something that we allow here. Direct estoppel applies to 25B2, as this court recently said in Aries. Judge Sanders disregarded that in 3 of the 4 bases that she relied upon in reducing this verdict, and that's why she abused her discretion. Thank you.
Thank you. All right, Attorney Levin.
Good morning. May it please the court, Patrick Levin on behalf of Melissa Pfeiffer. I would like to start with the place that Mr. McLean ended, because this was the chief ground on which they opposed the verdict reduction below, a claim that the judge was not legally permitted to reduce a verdict after the case had already been reviewed on appeal. They didn't make that argument in their brief. That argument is waived on appeal, and it's not an appropriate consideration for this court to reverse the judgment below. Moving to the issues that are appropriately before the court. Rules 25 and 30 vest broad discretion in trial judges to ensure that justice is done in every case. And contrary to what the Commonwealth said, there is at least one case, Carter, where this court explicitly said that the review conducted under Rule 25b2 and the review conducted by this court under Section 33E are identical. And this holding goes all the way back to Commonwealth versus Golden, which is this court's first case construing Rule 25b2, this second sentence motion of Rule 25b2. And they look to the reporter's notes, which specifically say the purpose of this rule is to confer on trial judges the same discretion that this court has in capital cases. So this is what the analysis is. You take a broad view, a holistic view of the entire case, the facts and the law, and you make a determination about whether justice has been done. Yes, Your Honor.
But counsel, wouldn't our discretion be limited in a 33E case or in a case after we already had full appellate review, if it came up again through a gatekeeper function, we would, if it was first-degree murder, we wouldn't have 33E reviews. So why isn't she then in the same position we would be in, which is we can't do, she couldn't do a 25?
Well, the reason is that this court never conducted the 33E review in this case because it wasn't a capital case.
Yeah, but it,
And so that question has never been addressed by any court prior to this motion, which it's a different legal question, right? So the question that this court addressed on the direct appeal is there's an error in the jury instructions. Was that error sufficient as a matter of law to require reversal of the conviction? And the court said no. There's no substantial risk of a miscarriage of justice.
Is the logic a little bit odd? I know what our case law says, but under Rule 30, of course, it's timeless, and we're looking for interest of justice. Rule 25B2 is directed to the trial judge. So now we have a situation 15 years later. Trial judge is long since retired and goes to the Raj, and the Raj either does it or appoints someone. That new judge never saw or heard or touched the witnesses or saw anything about the trial.
Yeah.
Isn't that a little peculiar?
Well, I agree that would be a little peculiar, and I do think there's a very big difference between addressing a motion to the trial judge who saw the evidence and addressing a motion to a judge who never saw the evidence. And of course, you know, that's what this, to the extent that this court has discerned a difference between the analysis under Rule 25 and the analysis under Section 33E, that's what it is, which is we're at a disadvantage here because we didn't get to see this trial. But the trial judge did get to see the trial.
All right, so take the trial judge out of it. Are you saying that we would accommodate that through our standard of deference, whether it be trial judge or non-trial judge under 25B2?
Your Honor, I haven't thought carefully about this before standing up today, but I'm not sure that it would be appropriate to address a Rule 25 motion based on the weight of the evidence to a judge who didn't hear the evidence.
Okay.
But
our
obviously,
case
that's
here.
not our
Yeah.
situation here. So I do want to speak just generally about the Commonwealth's direct estoppel claim. And
There's a case called Commonwealth versus Watkins. Did you address that?
I don't recall that case.
Okay, that seems to me to be a case on sufficiency where we talked about direct estoppel as well. And
I'm not familiar with
we
it,
use
Your
our
Honor.
sufficiency jurisprudence or just sufficiency discussion to say there was estoppel in that.
I'm not familiar with that case, Your Honor, but the point I want to make about estoppel is the thing that the judge is foreclosed from reconsidering is the correctness of this court's holdings. And so the judge could not reconsider the question of whether the evidence was sufficient. The judge could not reconsider the question of whether the error in the jury instructions created a substantial risk of a miscarriage of justice. The judge, writ large, is not allowed to decide that this court's holdings are wrong, that the direct appeal is wrongly decided. And that's the language in Arias, and that's the language it cites back to Sanchez for that. That's what estoppel is. And of course, the judge in this case did not second-guess the court's holdings.
Well, I mean, the judge doesn't come right out and say, I think the SJC got it wrong. But when you look through the factors that were listed in the decision, there is an aroma that the sufficiency wasn't enough because it was focused on the first issue, saying it was really weak evidence of intent, where on Pfeiffer, we said there was overwhelming
Yes.
evidence of intent.
So
Just let me get the other two. There was a revisitation of the jury instructions in the issue of giving the alternative theory. And I think more dramatically, there was this notion that it seemed to be infused in the decision that the judge felt badly about the timing of Brown, and that if this case were just a little bit older, this defendant would have gotten the benefit of that. And there was this repeated reference to the temporal proximity of trial in Brown. So how can we not come away with the feeling that this is exactly what estoppel is supposed to do, is to not have these things be revisited?
Well, I think the case that most clearly demonstrates that is Arias itself, So if you look at what happened in Commonwealth versus Arias, that's a case where the appeals court makes a decision about a jury instruction on defense of another. They say, now this is important, the appeals court's holding is that instruction wasn't wrong. Okay, and now the defendant comes back 9 years later, says, this instruction plus my youthful immaturity justifies a Rule 25 reduction. What the court says is that the judge correctly concluded that principles of estoppel precluded revisiting issues that substantially had been decided previously. The instructions in that case were previously found to be correct. In this case, the instructions were previously found to be erroneous, but not to create a substantial risk of a miscarriage of justice. So the judge, in considering, so it's important also to keep in mind that the judge's 4 factors in this case interrelate, all reinforce each other, and all speak to this question of whether the mental state possessed by Ms. Pfeiffer merited a conviction of murder.
I know your answer, but if we disagree with 2 out of the 4, is it an abuse of discretion?
No, and I said this at the hearing, is that just on the weight of the evidence and the mitigating circumstances, those 2 factors alone would have sufficed.
So sufficiency is different than weak.
Oh, it's very different. I mean, in the sufficiency analysis, this court views the evidence and draws all possible inferences in the light most favorable to the Commonwealth. But there's certainly, I don't want to speak because I think it really speaks to this question, about this question of the locked door that Justice Lowy mentioned. So there was sufficient evidence to conclude that Ms. Pfeiffer set this fire and then locked the door behind herself on her way out, thus preventing anyone else from escaping the building. That's how the Commonwealth characterizes the evidence in their brief. But the evidence did not strongly support that proposition. In fact, if you look at Mr. Brewer's testimony, he says, we had this fight, then I left and went to sell t-shirts at a bar. I came back and she had locked me out. And I talked to her through the window for a while, and then she told me that my friend had called me. I went to go see my friend. I was gone for a while, and then I came back, and that's when the fire is happening. He's already locked out of the house long before the fire started.
Well, I don't understand what difference that makes.
Because if she locked the door earlier in the evening and just didn't remember that it was locked on her way out of the house, that's a very different situation in terms of what her mental state was. And if you look to the transcript of...
Still had to leave and open the door.
Well, but the evidence suggests...
And make a decision then to lock it again.
No, the
because
evidence
you're saying
suggests
just-
that the door remains locked.
But she still knows that, correct?
Well, this is where her personal limitations come into play in this case also, obviously. And if you look at the transcript of the interrogation, that the jury had this part of the transcript in front of them, at record appendix, I think it's at page 72, and she explains that they taught her in school that if there's a fire, you close all the doors. And that's why the door was closed as she was leaving the building. And of course, that's a very different context, but this is where the limitations that this person has come into play.
So it's the point you're trying to make, just so that we don't lose it.
Yes, I'm sorry.
Okay. The point you're trying to make is the difference between overwhelming evidence, taking all the evidence, the light most favorable to the Commonwealth, on general intent, is different than how she might, Judge Sanders might have felt about intent in the way the case was actually tried.
Right, and this is a key point, and I'm thank you for bringing me back to it, because this question of general intent versus specific intent, the question for Judge Sanders is not, am I confident in retrospect that Ms. Pfeiffer is guilty of the crime of arson? That is the sitting as a second jury that this court says she's not supposed to do. The question is, am I confident in light of the entire case that justice was done at this trial? And so the fact that the specific intent instruction, which I want to note, has been in the Superior Court model jury instructions going back at least to 1995. There's a case out of this court in 2011 or 12, Commonwealth versus Tran, that favorably quotes that instruction, although it's not a holding, that specific intent is required, but they do the sufficiency analysis. So everyone involved in this case understood for the entire life of the case, right up until this court's opinion was released, that arson was a specific intent crime.
Let me ask you about the outside evidence.
Okay, yes.
We've never held one way or the other. We've held it on 33E. We've done it in practice at least.
Well, yeah, so
In Levesque, I think, and I did in Dowd, there's other cases. But we've never held on Rule 25B2, because it seems to me that 25B2, as someone that used to get these in droves, it's quite a different animal if the defense attorney says, hold on a minute, I need to have my person examined, we're gonna come back to you, and can I have funds for that examination? And then and we're gonna have a real 25B2.
Yeah, I understand. And so I don't agree with Your Honor, first, that the court has never addressed this, because Pagan, although it was a first-degree murder case, what this court was reviewing was the judge's order reducing the verdict under Rule 25. And it said that the judge properly considered evidence outside the trial record, including, and it doesn't say limited to, it says including the report of the expert who had testified at the trial.
The testifying expert, but I'm talking about something that's completely outside.
Well, so that's what but just to come to the point, which is that this is not new evidence in the sense that it is unrelated to the defense at trial. It didn't exist at the time of trial. I didn't submit anything on this motion that I didn't get out of the clerk's file. These are the two expert reports from the two experts who examined Ms. Pfeiffer before trial in contemplation of the trial in this case. And it's very important to note also that in terms of what Judge Sanders considered from Dr. Pfeiffer's report, all she considered is Dr. Pfeiffer agrees with Dr. DiCataldo about what these diagnoses are, and in fact, rendered a decision that was an opinion that was somewhat more favorable to the defense, and then the Commonwealth decides not to call her. But I just want to point out, going back, this connects up because all these factors interrelate to the specific intent question, that if Attorney Doyle had known that specific intent was not required, he would have tried this case very differently. And perhaps, given what he knew from Dr. Pfeiffer's report, might have gone and found a different expert and tried to assert a criminal responsibility defense. And this, in turn, connects up to this question of the holding of Commonwealth versus Brown. Because the reason that we don't apply that holding to cases tried before its issuance is that the case might have been tried very differently. And of course, that's true, although the Commonwealth hasn't identified any way it would be true in this case. But
here, I think it's fairly evident. We have a second-degree murder based on malice.
Yes.
Is one option. Then we have second-degree felony murder. Then we have involuntary manslaughter.
yes,
On wanton and reckless conduct. And as you appreciate, we've got the jury instructed on third-pronged malice and wanton and reckless conduct. And I'm sure their eyes are spinning, and as anybody else that reads these, right? And they say, aha, this is felony murder. Take felony murder out, then they're gonna have to grapple with third-pronged versus wanton and reckless. It would have been tried differently.
well, but that's
Pre-Brown, post-Brown, correct?
But so what I'm saying is, the state of the law at the time of trial is everyone understands that arson is a specific intent crime, and it can support a conviction of felony murder. The state of the law at the time Judge Sanders decided the motion is, now we know that arson is a general intent crime, but it can't support a conviction for felony murder. So in terms of fundamental justice, in terms of what's fair, I don't think
I
that,
was going more to your prospective Brown argument, because the reason you say would have been tried differently is that's the language in Brown, why it was prospective, correct?
yes. But, you know, in terms of, if the judge is considering the justice of the conviction, she thinks it's not just under the law as I gave it to the jury, for the reasons that she states regarding the strength of the evidence and the error in her instructions, right? So the jury is given these two options of the specific intent at the time of the fire, or we don't need to make any finding at all about her intent at that time. We can just rest on the truly overwhelming evidence that she didn't take any action after the fire had begun, which is, of course, overwhelming evidence of involuntary manslaughter. But the judge told them that that was evidence of murder. And so the judge says, well, this is not a fair conviction.
I don't know how anybody can say with certainty what is overwhelming evidence of third prong versus wanton and reckless.
Well, the third prong malice question, I agree. And but I'm setting the third prong malice question aside because the jury didn't find her guilty on that theory.
Right.
So the judge says, well, this is not a fair conviction under the law as I gave it to the jury. And it's also not a fair conviction under the law of the Commonwealth as I'm sitting here now. And so to say that because we thought the evidence of general intent was overwhelming, even though the jury that's not how the jury found her guilty. But now it only requires general intent. And so this is a fair conviction because the law changed subsequent to the trial without also taking into consideration that this court has also decided that it's not just for a murder conviction to be returned without a finding of malice. That doesn't make sense to me either. And you know, in terms of whether she could consider the error in the instructions, which she knows is not sufficiently serious to require reversal as a matter of law, but whether she can consider it in conjunction with her view of the trial evidence and decide that there's a concern that justifies a verdict reduction, I just want to point the court again to a case that is cited in my brief, Commonwealth versus Lanyu, which is a 33E case where the court does precisely that we perceive no reversible error at trial, but the charge on intoxication and premeditation, you know, although it may not constitute reversible error, was somewhat deficient, and in light of the slim evidence of premeditation, we're going to order a reduction in the verdict to second-degree murder. It's the exact same analysis. And, you know, in terms of whether she was stopped from doing that, I think Arias makes 100% clear that she's not, because the very last paragraph of Arias says, you know, so the defendant makes this estopped jury instruction claim and also in combination with this claim about his personal circumstances, and the judge denies the motion, and the court doesn't say, well, estoppel, we're finished, and you don't go further than that. It says, the judge noted that the defendant was 20 years old at the time and presented no evidence of personal circumstances or distinctive attributes that persuaded the judge that the verdict of murder in the second degree was unsupported by the evidence. Viewing the claim of youthful immaturity either alone or in combination with the alleged instructional error, the defendant has not identified any abuse of discretion. So the court recognizes, even in the Arias case, the very strongest case for the Commonwealth on this estoppel question, the court recognizes that it would have been within the judge's discretion to consider these two things in combination and make a decision about it. I want to make sure to point the court to the cases that I think clearly demonstrate that this court has already rejected the Commonwealth's claim about how Brown should apply here.
Are they in your brief?
Yes.
Do
So
you
the
wanna
cases
tell
are
us?
Pring-Wilson, Finney in the Rule 25 and Rule 30 context, and then in the Section 33E context, it's Castillo and Alcide. And unless there are
I have
further
one
questions.
question.
Yes.
And that is, if the defendant had brought this Rule 25 motion and Rule 30 motion before we had direct appellate review, the judge could have done this, could she have not?
Yes, certainly. And the Commonwealth recognized that below. But I want to make sure that you understand that she couldn't have brought this motion before the court reviewed the case because the judge still thought that she was right, that failure to extinguish a fire was arson. And of course, I'm way over my time. So unless there are more questions, thank you very much.